Hi, my name is Chooks Philip Ushiagu. I was called to the bar in 2022 and I represent public bodies as well as businesses in the employment tribunals. I present to you the Grounds of Resistance podcast. In this episode, I want to talk to you about employment status. Is someone an employee, worker, or independent contractor? Different rights are afforded to employees, workers, and independent contractors. That's why it's important to distinguish between employment status. Three factors are used to determine employment status, and no single factor on its own is conclusive. So, what are the key rights according to status? Only employees can bring claims for unfair dismissal, parental leave and pay, redundancy, the right to make a flexible working request. Employees and workers can bring claims for written statement of terms, national living wage, paid holiday, whistleblowing, discrimination, and health and safety rights. Self employed individuals can bring claims relating to health and safety rights, but discrimination protection is limited. Employees and workers are defined in legislation in Section 230 of the Employment Rights Act of 1996. Subsection 1 defines employees, it's known as Limb A. Subsection 3 defines workers, Limb B. The common feature here is that employees and workers work under a contract of employment, whether that's oral or in writing, as defined in subsection 2. So, how do we identify a contract of employment? We identify a contract of employment by looking at the multi factor test, also known as the irreducible minimum. Is there a mutuality of obligations and personal service? Is there sufficient control? And are the other provisions of the contract consistent with the contract of service? None of these factors on their own will be conclusive. The leading case in this area is Ready Mixed Concrete Limited versus Minister of Pensions and National Insurance. If all three factors are not satisfied, an individual will not be a Limb A worker, that's an employee. As we're going to discuss shortly, an individual may be classed as a worker or independent contractor instead. The government has published guidance on employee status, which isn't binding on the courts but will be persuasive. Factors that usually point to employee status is, for example, when contractual documents use terms such as employer or employee, the requirements to work regular or minimum hours, the requirement to report to a manager, the inability to elect a substitute, the payment of holiday, if the business provides the tools to do the job, the application of that business's disciplinary rules, the payment of tax and national insurance by the employer. If all of these things are present, this will point towards employee status. Mutuality of obligation and personal service requires one individual to personally undertake work and an obligation on the other party to pay for that work. If the employer offers no guarantee of payment, then the requisite mutuality of obligations won't exist. For example, see the case of Cheng Yoing versus Royal Hong Kong Golf Club. The claimant was not obliged to accept or be paid for work and did not receive any sickness, pensions, or other benefits enjoyed by employees. If there is no mutuality of obligations and personal service, this will point away from a Limb A employee status. Just turning to casual workers for a moment, the key characteristic in a casual working relationship is that there is no obligation to provide work, and equally, there's no obligation to accept work. Work is also irregular, and this negates the mutuality of obligation requirement. And so casual workers won't have the required mutuality of obligations to be classed as employees, but they will be classed as workers so long as the worker provides personal service and the other party to the contract is not a client or customer of the worker. So casual workers can bring claims relating to holiday pay, claims for wages, but can't bring claims for redundancy payment or unfair dismissal, which only employees can bring. A limited or occasional power of delegation isn't inconsistent with employment status, otherwise, nothing would get done. However, the employee and employer relationship is not characterized by an ability to elect a substitute. Where a substitution clause exists, that fundamentally undermines the requirement for personal service for a Limb A employee. So, what happens where that substitution clause gives a prospective claimant a right to elect a substitute, but this right is exercised rarely, if at all? Well, this question was considered in the Stewart Delivery Limited case. The tribunal held that the claimant was a Limb B worker pursuant to Section 230, subsection 3. The conditional right is inconsistent with the Limb A employee status, but because that right is exercised rarely, if at all, there is still a level of personal service to fall into a Limb B rather than an independent contractor category. Meaning that as a Limb B worker, the claimant still had the protection of certain rights which Limb B workers are protected from, for example, the right not to have wages unlawfully deducted. After considering mutuality of obligations and personal service, the next part of the inquiry is control. Is there a sufficient framework of control as per the case of Montgomery? Provided there is a genuine contractual right of sufficient control, it doesn't matter if that right is exercised. In Uber versus Aslam and others, it was held that subordination is control. This is because Uber drivers were subject to rigid controls in the app. Failure to maintain ratings could lead to a loss of contract. As a result, there was sufficient control to place Uber drivers into Limb B under Section 230, subsection 3, as workers, meaning Uber drivers were entitled to claim annual leave. The third stage of the inquiry looks at other factors relevant to employment status. This includes asking whether there is a sufficient level of control for finding of employment status. You do look at control in the second stage, but you come on to look at it again in the third stage of the inquiry. Financial consideration is also relevant. A person in business of their own accord will usually bear the risks associated with that business. Conversely, wage and salary payments usually point towards an employment contracts, but the labels aren't necessarily conclusive. In Stringfellows, a lap dancer received her remuneration directly from customers. She was judged to be an independent contractor. Integration is also a relevant consideration. Does that person wear a uniform, drive a company vehicle? Is the individual subject to a disciplinary and grievance procedure? That will usually point towards employment status, being an employee. The nature of the engagement and its length is also an important consideration. A person engaged to complete a specific task in a predetermined period of time that's short for a set fee, who also works for other organizations, may well be judged to be an independent contractor, whereas if an individual is engaged indefinitely earning a monthly wage working for one employer, this may point towards contract of employment, employee status. Employment related benefits such as sick pay and employee assistance programs usually also point towards employee status. By way of concluding remarks, there are three categories on status. That's employees, workers, and independent contractors. It's important to distinguish between them because rights are afforded according to status. To determine whether a contract of employment exists, you must apply the reducible minimum. That's the mutuality of obligations and personal service. Is there control? And whether the other terms of the contract are consistent with a contract of service. An individual who doesn't meet Limb A employment status, like a casual worker, because the mutuality of obligations is just simply lacking, may be a Limb B worker. A person who doesn't fall into a Limb A or B is likely to be an independent contractor, for example, where that independent contractor works for several other individuals or organizations. Thank you for tuning in to the Grounds of Resistance podcast. If you have any questions relating to employment status, do not hesitate to let me know using the contact details below. Further episodes will follow on other employment law topics. I just want to give special thanks to Mr. Yusuf Mahmood and Mr. Nicholas Radu in their assistance in preparing this episode. Farewell.